I'm Neil Davis, Senior Partner at Caddick Davis Solicitors. At Caddick Davis Solicitors, we specialise in the defence of drink driving offences. Those drink driving offences include offences of driving whilst the proportion of alcohol in breath exceeds the legal limit, otherwise known as drink driving, failing to provide a specimen, being drunk in charge of a motor vehicle, and also offences of being unfit to drive through drink or drugs. Now, these are all serious offences, many of which attract a mandatory period of disqualification of 12 months and often higher, save for the offence of being drunk in charge of a vehicle, which may sometimes attract 10 penalty points in the alternative. These offences are also serious, as whilst quite often they are dealt with by way of a financial penalty, the courts may also impose a community order such as unpaid work, or in the most serious cases, may even impose a sentence of imprisonment. As specialists and experts in this field, we are able to provide you thorough advice on any potential defence that may be available to you. Many solicitors who aren't specialised in this field simply assume that once you are charged with an offence of drink driving, then the offence will be proved and you will be convicted of the offence. That is, in fact, far from the truth, as drink driving offences are notoriously complex. They invoke a number of procedural issues, all of which can be used to defend the case against you. Now, that's not to say that you will have a defence to a charge of drink driving, and indeed nothing said in this video is intended to encourage a person to commit any of these offences, because of course people must be responsible when they drive and when they consume alcohol. But if you are charged with a drink driving related offence, you should contact Caddick Davis Solicitors to discuss any potential defence which may be available to you. Given the complexity of the law in the area of drink driving offences, there are a large number of possible defences which can be argued. Now, these defences range from factual defences to wholly technical defences. By way of example, factual defences can include things such as an argument that the person wasn't driving their vehicle, or indeed it could be an argument that the person was not above the legal limit at the time of the offence. More specialist arguments can also be advanced in appropriate cases to say that the person wasn't driving on a road or public place at the time of the offence. Now, beyond those purely factual defences, there are then more specific technical defences. So, for instance, it may be argued that the only reason that the proportion of alcohol in your breath, blood or urine has been above the legal limit is because you had consumed alcohol after driving but before providing an evidential breath specimen. That is known as a hip flask defence. And if it can be shown that had it not been for the alcohol you'd consumed after driving, then that will, in law, amount to a defence and an acquittal. Similarly, there are other technical arguments with respect to offences of being drunk in charge of a motor vehicle, which includes an argument that there was no likelihood of the person driving whilst the proportion of alcohol in their breath remained in excess of the legal limit. We can also have a large number of possible defences challenging the accuracy of the evidential breath, blood or urine specimen. By way of example, behind me we have the Lion Intoxilyzer 6000 UK, which is one of the evidential breath testing devices that the police use throughout the country to prove that you were above the legal limit. Now, it can be in certain cases that the device hasn't operated correctly, in which case it can be argued that the specimen is unreliable or inadmissible. I must note on that, however, that the devices which the police use for breath specimens are all type-approved devices and there is no inherent flaw in them. That means that in each and every case we must investigate the evidence which gives rise to the prosecution, and working with our experts, we can consider the evidence which the prosecution have produced and determine whether or not that evidence is in fact reliable. Given the procedural technicalities surrounding the taking of these specimens, there can also be technical procedural defences to the charge against you. So for instance, in cases where an evidential specimen is requested, be that breath, blood or urine, you must also be warned, must always be warned in advance that failing to provide a specimen may render you liable to prosecution. That is what we know to be the statutory warning. If such a warning hasn't been given, then the evidential specimen will become inadmissible, and that will amount to an absolute defence in law. Now, we've covered a number of defences there, and this video cannot conclusively address each and every defence which may be available. However, our purpose here today is to demonstrate that these are offences of complexity, and that if you are charged with a drink driving offence, as specialists, as experts in this field, we will be able to analyse your case and to advise you as to whether or not a defence is available to you. And in each and every case, we will provide you with very honest and thorough advice as to the options open to and available to you. So if you find yourself investigated or charged with a drink driving related offence, please contact Caddick Davis Solicitors in order that we may have a consultation with you.